Welcome, everyone. My name is Oishik. I teach at the Jindal Global Law School. And welcome to the third day of the Global Law School Summit. This is a particularly exciting session titled Touching the Constants, Renewalism in Black Letter Law. I will introduce our very distinguished panel of speakers in a few seconds. But before that, I want to give you a very quick introduction to the theme of the panel. As we know, and as the discussions in the summit has borne out quite compellingly, that legal education, irrespective of its jurisdictional location, hasn't been untouched by the tectonic changes that have been brought in by globalization. And it isn't a contemporary phenomena any longer. It has in fact become a historical phenomena of law being responsive to changes that are taking place the world over. And these changes are not only changes concerning the way in which we generally think about globalization in terms of the economic opening up of borders to capital, but also both the celebratory as well as the tragedy-laden movement of peoples and ideas as well. The provocation that this panel places before us is to actually negotiate between holding a place that remains committed to a historical moment while at the same time remaining future-facing. We would sometimes tend to think about black letter law as the foundational element that enables us to build an idea of law, legal theory, or jurisprudence, while at the same time, we do have legal scholars who would think about black letter law or holding on to black letter law as a particularly conservative way of thinking about law or legal theory. Now, what does one do at a time where change is the constant, where we are constantly trying to re-energize law to respond to global shifts, be they cultural, economic, or political? Is there some worth in holding on to the historical significance of black letter law? Is it merely a conservative move to look backwards? Or is there something to be gained from a commitment to a historical vision in law that takes the black letter law seriously? And we're not necessarily proposing that it's an either or approach that can help us when we think about black letter law from our place, wherever that might be, given that our speakers are quite variedly situated in different parts of the world. So that's broadly the provocation offered by the theme. And to respond to this provocation, we have three distinguished speakers. I'm told that our fourth speaker, Mr. Nitin Rai, is unfortunately not able to join us. So let me introduce the other three speakers on this panel. We have Professor Ayodele Atsenuwa, who is the Deputy Vice Chancellor at the Faculty of Law, University of Lagos in Nigeria. Welcome, Professor Atsenuwa. We have Professor Martin Hogg, who's the Dean at the Galway School of Law at the University of Edinburgh in the UK. Welcome, Professor Hogg. And I have my dear colleague, Professor Sourav Mandal, who is an associate professor at Jindal Global Law School in Sonipat. So let me start off with the first question, to which I'll request our speakers to respond with, within 3 or 4 minutes, and that's the kind of Q&A back and forth conversation format that we'll follow. We generally think about globalization as a phenomena, particularly the way in which it has affected legal education and legal theory, to have broadly kind of divided our idea of law into something that can be referred to as mainstream on the one hand and critical on the other. And in this kind of binary that's been created between the mainstream and the critical, would you think black letter law is what we tend to associate with the idea of the mainstream? We can follow the format of the speakers as I had introduced them. So Professor Atsenuwa, you could start us off.
Okay, thank you very much, Oishik. Yes, what is black letter law? Black letter law, we would usually assume, refers to the well-established rules of law, the ones that are not subject to change, and it's law as it's in the text and ingrained, but to argue that black letter law, or to suggest that black letter law is static, is something that I have always challenged. I think that law has always been mutating, even when it would lay claims to being constant, but in between. And so, one thing that we're familiar with as scholars of the law is the exceptional principles and the constancy of exceptions to main rules, so that I would say that it is not quite the case that black letter law and critical, legal theory or critical law are poles apart. Law's always been challenged. What we call the dominant principles, the well-established principles, I think the only thing that we know as constant in law is actually that we're forever challenging the principles. And so even though we will say that the principles do exist and that this is black letter law, but we spend all the time telling our students also about all those exceptions, which they always have to adjust to. And in fact, I think I had someone say once that I think it was a dinner joke, and it was like, I'm looking for a lawyer with only one hand, as against, on the one hand and on the other hand. And someone said, can you just give me a lawyer with only one hand? Because I'm a bit tired of this on the one hand and on the other hand thing. So I would say that, yes, globalization is come, and it has come with developments that make us challenge the adequacy of the law that we know. And as we begin to, as law begins to take off the dark, take off the dark band across the eyes and begins to see, which is what, we will say that critical legal theory is all about, and says that, no, you can't pretend that law impacts everybody in the same way. As we begin to force that, into the contention, law is responding. And I would say that the reason we've always had specialist areas of law, no matter how peripheral it may seem that they have been, is because we've also recognized that, we need to have those special adaptations to accommodate. And that is, so globalization is forcing us to take on, those new challenges, but I don't think that they might just be asking us to do it more open. It might be that we're being asked to do it more openly, more obviously than law used to accept that it was doing.
Right. Thanks a lot. I mean, I think you offer a return provocation to the theme of the panel, which is to not think about the mainstream and the critical as binaries, as a more conservative way of thinking about black letter law would want us to. Let's see where Professor Hogg takes us from there.
Thanks very much. I should just start by saying that I was at the University of Edinburgh and now at the National University of Ireland, Galway. They're actually two different institutions.
Right.
I think
So yeah. My mistake. I should have.
That's quite all right.
That.
Yeah, moved from Scotland to Ireland, where I am now. I think I would echo the comments of our previous distinguished speaker. I think one of the sort of ruses that critical legal theorists have sort of pulled on us in recent years is to give the impression that they are the only critical ones. Whereas I think actually, if you look at the history and development of the common law throughout the world, it's always had within it that self-reflective critical aspect to it, which has enabled the law to be developed within the proper boundaries within which judges can develop the law as opposed to the legislature. So I think the very idea of the common law and the idea of judges gradually reflecting on, reforming and developing the law has inherent in it a degree of criticality and self-reflection, which otherwise would render the common law completely sterile. And I think if I look, for example, at my own field of the law of obligations, and let's go back half a millennium, go back 500 years ago, the law of contract didn't really exist at that time. There was different actions within the law of contracts, a sumsit covenant and so forth. Tort was completely different. The law of unjust enrichment didn't really exist. If there had not been the degree of critical self-reflection on the way in which we should think about the subject of the law of obligations, we would never have got a unified law of obligations as it is today within the fields of contract and tort and restitution, unjust enrichment. There's always been that developmental pool within the law, common law, which has drawn it forward to try and think whether the needs of the people it serves are being met by the law in its current state, or whether it should develop in new directions. Of course, the trick for judges is to make sure that they are trying not to tread on too much on the toes of the legislature, because if they start to do that too much, then they are really taking legislative power to themselves. And that's been one of the great debates, hasn't it, in the common law over centuries. What is the proper role of the legislature? What's the proper role of the judiciary? And trying to find that degree of critical self-reflection which is appropriate for the courts in developing the common law has been one of the challenges that society has faced over time. I think looking around the common law world today, there are probably slight differences in the role of the courts in different jurisdictions, but I think all of them would say, if you ask judges from all common law countries, does your role involve a degree of critical self-reflection, leading the law on to develop in ways which reflect modern society? I think they would all say yes to some extent. So I would agree that there really isn't this binary between mainstream and critical. I think the critical has always been part of the mainstream, albeit that if the courts depart too much from interpreting the law as it is, then they run the risk of stepping out beyond the proper bounds of the judicial function.
Right. Thank you, Professor Hogg. And I think you're taking forward Professor Atsenuwa's argument about trying to kind of, in a certain way, rehabilitate the critical origins of the common law itself, that the critical position didn't necessarily emerge from outside the tradition, but the tradition has enough resources for us to identify criticality within it. And one can actually see that if one sees the degree of discretion that the common law has over time in debatable forms, introduced as far as the authority of judges in the common law tradition is concerned. Two excellent set of comments, actually helping us kind of produce a rehabilitative move, as it were, with regard to the black letter law, element in the common law tradition. Let's see what Professor Mandal has to tell us, whether he'll kind of take the rehabilitative move ahead or introduce a counter provocation. Over to you, Sourav.
Thank you so much, Oishik. I would call you Oishik, and please call me Sourav, I think. And thank you so much for having me in this panel. It's really a pleasure to be a part of such a distinguished set of, I think, panelists. I think I would start with Professor Professor Ashwina, I'm sorry. Yeah, we just had a discussion. Okay, thank you. So I think I would like to sort of start from there. I think she just started with this remark that what is black letter law? And I think that is very important for us to first of all kind of expound. Although Professor Hogg has already sort of, I guess, given through the example of common law, I guess Professor Hogg has already brought the internal inconsistencies within the common law system and how common law itself has its own corrective abilities, and it has over a period of time through debates, deliberations, and contestations, it has sort of come up with changes. Certainly that is true. However, having said that, I think what we kind of miss often in our day-to-day, practice of law and legal scholarship in the academia is that the scholarship as well as the classroom discussions, courtroom lawyering, where law is applied, it uses the tools and the assumptions of the black letter law. And I think the problem that the critical scholars have with the black letter law are at a very core level of certain assumptions and the sort of tools that the black letter law often assumes to, on the face. And I think that is where I guess some of the problems come up. However, I think, again, I mean, law has been very corrective in many possible ways, but it's very important to sort of also bring the critical element very consciously in classroom teaching into courtroom lawyering, if possible. For example, the use of ethnographic data to sort of teach constitutional law, for example. I guess that could change the way a student approaches law at the first place. So for example, when we teach citizenship law, for example, I think it's very important not just to teach them through conventional black letter law methods of teaching, like case law methods, for example, but to also take the discourse out of the classroom and use other legal and other non-legal methods of, I guess, interventions to sort of also introduce these topics of vital concern. So I think in that sense, of course, there is no binary or a sort of a either or kind of scenario, as Oishik has already pointed out at the beginning. I guess we need to sort of look at it how the legal framework as a whole can enrich itself with the presence of, I guess, different other systems of knowledge. And the last thing that I would just end up with by saying that there is no taxonomy of any kind is going to really work of any sort. I think we need to sort of, I guess, work more in tandem with other different knowledge systems. That's very important. And that might come from different other branches of, I think, popular culture, understanding popular culture, or understanding, I guess, just in other possible different ways, how human experiences could contribute the meaning of the law, not necessarily to always look at it from a top to bottom approach, with its very typical assumptions. But I think also to sort of look at law from the subaltern perspective and to sort of kind of look at law with sort of kind of just break the black letter assumptions of law and to look at it from a critical perspective. I guess that is more important. So thank you for now. Yeah, I'll end on that. Yeah.
Thanks, Sourav. So I think with Sourav, your comment, we see an interesting line, a parallel line drawing emerge, unlike the line drawing that Professor Atsenuwa and Professor Hogg tried to unsettle. The initial line drawing, which was part of the provocation of the panel, was drawing a line between the mainstream and the critical. Their arguments help us see that that isn't necessarily a helpful line to hold on to. You are introducing another kind of element in the discussion, which is to think about unsettling the line that distinguishes the law from what is not law, which is to say things that we generally tend to consider to be even outside the discipline have an important wisdom as far as how legal knowledge is understood. So you refer to other disciplinary perspectives like anthropology, for example, and what you're saying might also be in line with some historical ways of thinking within the common law tradition, not necessarily located in the UK. So if you think about American legal realism, the argument that judges need to look at sociological work or public policy work to help them arrive at better judgment might be somewhat one of the roots of the kind of line drawing you're suggesting. Let me introduce the next question, which I think flows from some of what you were saying at the point on which you ended, Sourav, which is the question of power. And I think the big grouse really, if we were to think about the relationship between the critical perspective and the so-called mainstream perspective, again, it's poor of me to use those descriptions because I can't think of other labels, but I do think that they are inadequate labels. But the kind of central grouse that exists, if we were to continue to use those labels, is the presence of an analysis of power in the way in which critical scholars would approach their analysis or inquiry about the law, whereas mainstream scholars with a certain kind of commitment to the timelessness of principles or rules would want to make law immune to the workings of power, which primarily would be in the realm of politics. So my question back to the panel is that historically, can we rehabilitate the Black letter law tradition by thinking about whether the Black letter law tradition in fact has an account of political power, or is its continuance and legacy about keeping political power outside of the way in which rules and principles and commands operate? We could reverse the order of the speakers, but or go back to the same order. Professor Atsenuwa, do you want to come back in?
I said it looks like Sourav is really keen to say something, and maybe I should let him start. Did I see his hand up?
Sure.
All right. Yeah, no, Professor Ashwina, if you would like to go ahead, that would be perfectly fine. Please.
Okay. Yes, I think I would just, yes, I would like to have a go at that. I think that speaking from the experience of being a law teacher, a law scholar in a state that was colonized, and the teaching of law has always been interrogating, at least from about the 80s. It has been less settled when initially in the 60s, probably, in fact, I would say that as far back as the 60s, you would find that the areas of law that were most engaged, admittedly, was private law, especially as people started to interrogate, things such as land, the law of property, and, interrogate the family law principles that were like adopted, or imported because of colonialism. I think that tradition of interrogation has consistently remained. Actually, in my curriculum and the way I will teach, there is no principle of law that students are taught without some engagement, without some interrogating. And interrogating in the context of, the North-South debate, particularly because you would find that all too often, you find parallel, you have the people's law, which is the lived reality, the one we see people live by every day. And so we're constantly asking, so why do we have the formal law, but we have a sizable population living out of the formal law? Because the students will always ask you that. For example, that if I'm in human rights law class, the students will say to me, so we have this right, but what is the reality? And so we've always had to interrogate those issues. And maybe that's the backdrop against which I will say that even when we talk about Black letter law, it's always the self-reflexiveness possibly has gone a bit further than it might have done in some other jurisdictions that didn't have, or that doesn't have that reality of about half of the population living, under a completely different regime of law that you could say runs parallel with the formal law. And I will say that when it comes to power is always, because of that reality, power has always had to be interrogated. Whose law is this? And why are the people silently, passively resisting the law by not coming under its umbrella? and negotiating their lives outside of it. So I would say that, yes, necessarily, we have imported that, although there have been lately greater embracing of, you know, the interdisciplinary approaches, greater embracing of the methods, you know, valuation of the methods of inquiry in other disciplines. And maybe because, you know, it's in the field, because I teach human rights law, and I also teach gender and the law. And these are fields that must necessarily interrogate, you know, power relations, because these are areas where the law forms and the law system seem to run parallel with what it is you see every day. So I would say that, yes, in our context, speaking from the Nigerian context, the discourse of law, maintaining that tightrope distinction has never been something possible. It wasn't possible because right through colonialism, there was the challenge to everything that was like imported common law. And then through, in the post-independence era, it's also been a very dominant approach, and then globalization comes. But what is important is taking us outside. So while these engagements took place very readily in class, in academia, the same didn't always happen in practice. And you will sometimes, we also had the reality where we were told that, oh, that's academic. That has nothing to do with what we're doing here because the rules are set. So it is, what we have tried to do now is, how do we get the transition? How do we get the validation of this and the legitimization, excuse me, please, of those discourses taking place, you know, in legal academia, and getting it to redefine the principles that the courts are. And that's where, you know, we get the challenge. No, the principles of law are well settled. You know, you can't bring all those here. You need to go and get the changes in the law outside of, you know, you need to go back to the legislature before you can have these radical reforms that we're pushing. But we believe that the growth of the law is hinged on how open the law is to these critical interrogations. And we believe that we stultify law if you do not engage within practice. But I think that we're seeing a little bit more openness. Of course, I agree that there are those who think that we're going too far astray and we should bring back law on course.
Right, thank you so much. And thank you for bringing the discussion, you know, back to questions of pedagogy. And, you know, maybe we'll have an occasion in the next round to attend to this, but it might be interesting to think about whether certain areas of legal study or research lend themselves more to a certain kind of critical orientation than others, or is that too a myth, and it is possible to kind of think about more traditional law subjects, unlike, you know, gender and law or human rights law, that you know, their beginning point was a certain kind of interrogation of received wisdom. But it's interesting that in our constant attempt at unsettling binaries, we also constantly produce binaries. So, you know, the challenge to the binary between the mainstream and the critical, for example, has also produced the binary of the law in books and the law in action, you know, the realist distinction. And it seems a productive binary in many ways to hold on to, even if the first binary that we wanted to challenge appeared to be not as productive. Over to you, Professor Hogg, in response to the question about power.
Oh, I had to unmute myself there. Yes, I mean, I think, again, it's a bit of a caricature to say that black letter law, traditional law, is not interested in power. As long as it sees what the law is, it doesn't care who enacted the law or how it got to be in the way it was. I mean, I think my biggest piece of evidence in support of the fact that that's a bit of a caricature is, if that were true, we would never have, the law would never have taken an interest in equity. The whole realm of equitable jurisdiction would simply not have arisen. And of course it did. And it did because very early on, the courts of chancery grew up because the Lord Chancellor and those around him were interested in the way in which legal rights were being abused in a way which had a negative impact on people. So we get this whole jurisdiction of equity which arises because the law says we have to look beyond what the black letter is. We have to look at the effect it's having. And if people are abusing their position to enforce results which are inequitable, we have to do something about that. And that isn't just a dead jurisdiction, it's still alive today. There are still very lively debates going on in the law about developing new areas of concern for equity, or indeed, to use a kind of modern term, good faith. If you look at the law of contract, my own field, you can see there are very lively debates going on now about good faith and the role that good faith should play in contract law, and the belief that one shouldn't just get to exercise remedies in a way which would be contrary to good faith. Now, of course, there's a big spectrum of views on the role which good faith should have, but I think there's a growing realization in the common law that contract law, if it is to reflect modern mores, has to take account of requirements that someone is acting in bad faith, and that should limit the remedies which they would otherwise be entitled to in black letter law. So I think I would say that there's always been a tradition in the law of looking beyond the black letter and seeing the way in which power can be abused to achieve undesirable outcomes, and that the common law has developed responses to that as required.
Thanks. Thanks again. And interestingly, the point that you make, and we possibly in the next round, I'd try and frame a question that attends to this more closely. We do see an emergence of a vocabulary here within the common law tradition that uses other words to talk about power, for example. So clearly the historical insight and its contemporary relevance through the law of equity that you're referring to attends to questions of authority, in a certain sense, and accountability. For instance, again, both of these words as part of a larger vocabulary that is interested in questions of unequal distribution, concentration of a certain kind of discretionary authority, has also traveled into other areas of law like human rights law. And so, I think your earlier point about kind of putting these impregnable walls isn't in fact helpful, because historically we've seen far more kind of conversation take place across disparate areas of law than we would want to think, especially when we think from a critical point of view, which can be read if one wants to critique in that sense as establishing divisions that possibly weren't in fact in place. That's what you'd call in the way you put it, a caricature of sorts. It's, one could say it's historically been far more contingent rather than how the critics make it out to be. Thank you again. Sourav, you want to come in on the power question?
Yeah, I mean, I think I would like to sort of course, appreciate both the trajectories that I think both of our speakers are taking. And I see a bit of, I guess, two different trajectories, in the sense that I think Professor Atsenuwa started with a very, her experience of being working in a post-colonial state, and sort of she shared her experience of how law teaching has sort of changed from how it was in the 80s and how now it has been changing. And I think there, I guess we need to sort of start with this very important question, whose law it is. I think that's what Professor said. And I think Professor Hogg's, his description of the equity law as a sort of a kind of a internal method or within the black letter law to sort of check the tyranny of the common law in a way, or the tyranny of rather the more strict implementation, enforcement of the common law principles, and as an alternative, therefore, equity law as a different kind of a sort of a subsystem grew within the larger legal system, which is true. However, I think we also need to appreciate that there are two very different aspects over here. I mean, both the trajectories have a lot of value in it, and I think we need to sort of appreciate that liberal legal frameworks have essentially frameworks which allow inclusion, and liberal legal frameworks allow principles like rule of law, for example, or a democratic method of lawmaking, for example. But then, to what extent is the lawmaking process really democratic, or to what extent is the knowledge production when it comes to lawmaking, is it democratized? In other words, are we taking, for example, when we are making laws for a certain interest group or certain groups, are we really taking their perspectives really? For example, I think in the case of the UK, I mean, the Gender Recognition Act of 2004 had been facing a lot of trouble, although it was made into a law in 2004 under European courts, I guess, orders. But now UK is changing its gender recognition laws, and very soon probably. But the kind of deliberations that UK has now had, or the British Parliament has now had with respect to changing the Gender Recognition Act, I think it speaks a lot about how pre-legislative processes are really very sound in the case of the in the case of the I guess the lawmaking processes followed in that part of the globe. Whereas when we see the need for changes in the pre-legislative processes in India, I think we have a long way to go. And why I'm bringing pre-legislative processes over here is because the idea is, again, for whom are we making the law, right? Whose law it is after all? Where is the power coming from, right? Or who is holding the power, right? Who is not ready to share that power, right? So I think we need to really look at it from that perspective. If the liberal legal framework allows, I mean, although these assumptions are very problematic, like when we say rule of law, it's a very deeply problematic assumption at the first place. And lawmaking is not objective. It is deeply political in all possible ways. And especially when you allow, I guess, deeply ethno-nationalistic sentiments or kind of muscular majoritarian sentiments to sort of become what the law would then be, I guess then this needs to be challenged. And I think one of the ways, or different ways in which it could be done, is to have an engaging pre-legislative set of processes, good legislative processes, good legislative discussions, and at the same time, good post-legislative discussions, and to take the courts, to use the judicial review methods to sort of question laws, if in case there is a sort of a majoritarian, kind of a sort of what you call a kind of attack on human rights, or sort of the way. So I think in that sense, I guess to close it, I think black letter law, it somewhat hides in itself, but not because of the sort of not because of these sort of, I guess, essential principles. The principles by and large could be okay, or they could be used in a much more beneficial manner for a more pluralistic or a more broader, diverse benefit of the society, for the heterogeneity of the society. But at the same time, it often doesn't happen like that, because black letter law has a possibility to really hide, or allow certain categories of, or certain sections of the society to sort of retain the power. And I think that is where, I guess, it needs to become more open, and knowledge production has to become more democratized, in other words. Right. I'm not sure how much sense is this making, but yeah, this is what I would like to sort of put it at the moment.
Right, thank you. Thank you, Sourav. So I'm going to hold on to just a couple of points from what you said so that we can segue into the next round. So your response to, amongst the other things that you said, one was to try and think about a way, a practical approach to bridging this gap between law in books and law in action, knowing that this transference is not as easy as it generally sounds like. So you're suggesting a particular practice like pre-legislative consultations or post-legislative consultations that bring in the wisdom of the people who live with the law, rather than merely kind of falling back on the wisdom of the experts, as it were. That in itself, in many ways, unsettles the question of where does power lie. That, I think that was one helpful idea from from what you said. The other, and that might take us to the next next question, and drawing from what you were saying, is that black letter law principles prima facie might appear good. So the rule of law is a good idea. It's you can't fault it for its promises, but it does hide a certain set of things, and opening up a rule of law to what it hides might actually be able to help us make use of the idea better, rather than to take it as it appears. Now, the question for the speakers, the third question, is with regard to the work that black letter law principles do as they move outside of their jurisdictions of origin. And this takes me back to a point that Professor Atsenuwa had made about the aftermath of colonialism, and how post-colonial countries who've inherited the common law tradition have to constantly negotiate between holding on to contradictory pasts, that you don't let go of the common law tradition, but you're also trying to figure out how other diverse plural forms of law coexist with the common law tradition. Now, the question that I wanted to pose to the panelists is, if we were to take, seriously the promise of a certain set of black letter common law principles, like the rule of law, for example, how does one historically account for the, one could say, the violence that's been carried out through the use of a principle like the rule of law in advancing and justifying colonialism, for example, to say, that part of the world does not have the rule of law, so it is our task to actually take the rule of law there. In many ways, one could say that several post-colonial countries have been beneficiaries of that transference, but that transference has also come at the cost of possibly killing off several other diverse or plural, legal traditions that might have existed in that area. The American legal scholar Robert Cover uses a particularly evocative word called jurispathy in the context of judicial decision-making, but it seems like the travels of the rule of law outside of Europe also performed a certain kind of jurispathic role in killing off plural legal traditions elsewhere, especially in the context of colonialism. So the question really is, how do we hold on to black letter law principles, knowing well the historical baggage of violence that they currently carry? So it's like the question is about historical negotiation with a certain set of really important black letter law principles. How do we do that both in terms of pedagogy, but also, practically in, the kinds of lives that we live or what we expect from the law today?
Thank you very much, Oishik.
Yeah, please.
Professor Hogg, do you want to go?
Well, I can just give you a very, very, very brief answer to that
sure.
question. I mean, first of all, I'm not sure I would say that the rule of law was a specifically black letter law principle. I mean, I think the rule of law is more a fundamental ordering constitutional principle of a legal system. It goes simply beyond whether you are engaging in black letter law thinking or engaging in critical legal thinking. It's more of a foundational principle, which I think cuts across different approaches to thinking about the law. But having said that, I'm not sure that I would ever have thought that the principle of the rule of law was a guarantee against oppressive conduct, because if you go through a process of enacting law and enforcing the law, and you therefore can be said to be respecting the rule of law, that's not a guarantee that the laws that you have implemented are going to be just. You might have very oppressive or tyrannical laws. So I think the rule of law on its own is never enough to guarantee that you don't have an oppressive system which fails to respect minorities, fails to respect diversity. I think you need other substantial constitutional values to do that for you. So first of all, I wouldn't say that the rule of law was specifically a black letter law rule, but additionally, whether or not it is, I don't think it is a guarantee against oppressive colonial practices. I think you need other things in place to prevent that from happening. So that would be my quite brief answer to the question.
Well, I think, thank you. I would say that actually, as I sit here reflecting on the questions, I see how, the very principles, just like Sourav has tried to help us understand throughout this conversation, if you take the liberal approach and you assume that because black letter law has within it the elements for some insurrection against it, so for its recreation, you also may miss the opportunity, you may miss out the fact that it's historically it has served, to respond to some power dynamics, and then it shuts the door against some other power dynamics. And the illustration I just wanted to give was, so you have the criminal justice principles, the presumption of innocence, the proof beyond reasonable doubt, and the issues of the evidentiary weight that will be accorded to some kind of evidence, and whether the right of the defendant, to confront, the accuser, and all of those things. And when you come into it from, gender-based violence, for example, and you then suddenly realize that those rules themselves become, like they shut the door against justice. Because from what we then know, we go back to what we said, learning, looking at the realities from other approaches. And then you realize that, yes, the victim does not want to confront, or the survivor does not want to confront the assailant in open. The victim does not immediately talk about, does not provide all the details because of stigma, shaming, or maybe trauma. And, you find that, so you come up with something 6 months later, and it's like, why didn't you say that when it just happened? And so, yes, I agree. I verily agree that, we need to constantly pressure. So the rules that were designed to protect the accused person, the defendant, against the state, then shuts out the victim. When you get to it, or shuts out, is insensitive, where you consider that crime as it was then understood was what would happen to men, and this is the way men would respond to it, as against, now that we're looking at gender-based violence, is a different type of violence from the other type of violence because of the way women are socialized, whether, or maybe the way they are biologically. Don't let's get into that conversation, but it then tells you how very easily. So yes, I do agree with the question, how do we hold on to the values of black letter law, those principles, and at the same time, create the spaces? And I think really that is what gender justice is all about. So it says, yes, we have adversarial, in the adversarial setting, we need proof beyond reasonable doubt. We need that the person who accuses must prove, we need all those things. But the reality also is that it doesn't, the victims, victims of crime they're not one, and they come from different settings and all of those things. And I think that law is being forced to respond to it now. Law's been forced. Possibly one of the earliest things we have is giving evidence in camera, some of those things that, because otherwise, and then, but one area that I think we must really look at is, it's like, what kind of evidence, what happens, what are the rules of evidence? Can they accommodate, what we need if we're going to do gender justice? It was easier when you talk about child justice, but I think gender justice is actually forcing, it's forcing those changes. It's making us say, these rules will not do justice in this context, because it goes back to what we said about, the power, and shutting the door against because you hold on to. It's slow in coming, But I think the tweaking is already taking place. But what I just want to say is that typically, what we're doing again is using the spaces, which is what I think I started off with, and Professor Hogg did, and just, is using the spaces for insurrection within, the traditions of law to challenge the dominant, to force this. And that is why it may be slow. That is why it seems dissatisfactory. But in terms of practicality, I would say that really is what is more likely to give us something. It is slow, but I doubt that we can completely dismantle. And in any case, there are enough people who have internalized the inherited laws, the values. I always say, okay, so I say in my class, so you say this is the custom, but there is a sizable number of people who are no longer living under this custom, and they do not want this custom. So you've got to have a legal system that responds to the fact that you can't take us back to that customary place because a sizable number of us are no longer there, and yet there are those who want that. So I think it's evolving. So yes, there is some, and it is when you have those challenges that you get people say, you know what, this is getting too fluid, this is getting too difficult, let's just go back, let's just hold back to the safe quarters, the safe boundaries of what we know as law.
Thanks a lot, and those rich insights, both Professor Hogg and Atsenuwa. Sourav, did you want to comment?
Yeah, sure. Yeah, thank you so much for, I think, both the very insightful comments, and I think the question could be rephrased, if you like. I think in the sense how Margaret Davis puts in one of her pieces on pluralism, the ethos of pluralism, and she writes that how can we maintain the integrity of law as a system while recognizing the need for it to be more socially responsive, flexible, culturally inclusive, and adapted to other normative systems. I'm not sure if Oishik would agree to this or not, but I think this is the question, I think, perhaps. Now, if that is the case, then I think we need to understand that lawmaking or law per se is not objective. And these ideas, the principles of law at the same time as taught to us but intergenerationally are not objective either at the same time. In the sense that if you talk about rule of law, let's say, for example, which we have inherited certainly from, in India at least, from a colonial, knowledge systems. And very clearly the idea, or there could be different debates of how rule of law could be, or has been also there pre-colonially as well. One could always have different types of scholarly engagements on that account. But on a more, clear level, rule of law comes into the Indian legal system from the common law system, right? And if that is the case, then I think the idea of equality before law has its structural limitations in many possible senses. The idea of treating everybody with one objective standard of treatment, taking the society, assuming the society as a homogeneous group of people where one size would fit everybody, has its own problems. And we have seen that across different litigations in colonial and in different post-colonial societies, as well as different first world global north countries as well. I mean, there are clearly limitations of having a very structured notion of rule of law. So I guess obviously we need to sort of understand equality in a more broader framework of substantive equality, and to sort of, I guess, take it beyond a very conventional realm of equality before the law. But having said that, I think Oishik's question is about negotiating with the historical injustices. I guess if we come to that, I would like to take two examples, one from family law and one from criminal laws. What we have inherited from the colonial laws in terms of a family law is a deeply gendered notion of family, is a deeply heteronormative notion of family. And we are really struggling in India and in different other post-colonial societies. And also, I think this is the challenge of many different other societies of the global north as well. I think in many different ways, to sort of negotiate with this very heteronormative set of concepts, that you bring in when you come to describe what is a family, right? How gender roles kind of inform very clearly what is a family. And that is a foundation to our family laws. So how are we negotiating with that? I think that's a big question. I think the different changes that have, I think different legal systems have taken quite a few trajectories. For example, France has had a very different trajectory, although it's not a post-colonial society, but I think France has had a very different trajectory of sort of understanding, I think, cohabitation in general, irrespective of whether or not it happens between same-sex or, cross-sex couples. But again, the idea of normativity comes up, like with two people in a relationship. The French law of PACS, which, defines what is unmarried cohabitation, non-marital cohabitation. It simply understands a family as a unit of two people, whether or not they are married, irrespective of that. There are also countries that have taken the marriage route. There are also countries like South Africa, I think, where that is not the case, or it is both ways. But I think it informs a lot of how you are then defining domestic violence, how you are then defining all the other different realms of private and public law remedies. Criminal law, another very important point that we have inherited, the historical injustices, the assumptions of, I guess, a lot of binaries that we have inherited from the colonial, framework of laws. Sexual assault, for example, is a deeply gendered, concept for that matter. The male as the aggressor and the female as a victim. And I think we are struggling to change that in India. Although I guess there have been changes with respect to making it more comprehensive, but again, in this very heteronormative frame of male vis-a-vis female, that sort of a framework. I think I'm not sure of what would be the better ways to sort of, I guess, maybe change it, but I think more critical engagement with the law is very important at every stage. I think whether that be just simply the courtroom, whether that simply just be the classroom or beyond the classroom, popular media, I guess, in all possible ways, we need to sort of engage, and sort of then create that vocabulary, which is already there in a way, with the help of critical scholarship, I think. But I might be wrong. But yeah, these are my submissions for now. Thank you.
All right, thank you, Sourav. So I think I'll mute my questions because we do have a few questions from the audience. Srijit, will you alert me? We did have an additional five minutes. Okay, great. So we can take about 2 audience questions, I think. And the first question, I think, in many ways speaks to a comment that Professor Hogg had made about, the fact that it's not just the presence of a principle that ensures, that one can stave off injustice, but you need other institutional mechanisms to be in place, other arrangements to be in place, like the Constitution. And this is a question about the Constitution, particularly in the context of judicial activism. I put the question out there, and whoever wants to take it, amongst the panelists. So this comes from Lakshmi Srinivasan, and the question is, can it be said that even in the light of judicial activism, constitutional law believes in grounding itself in black letter law? That the Constitution doesn't escape its commitment to the black letter law. It seems like what Lakshmi's question
I suppose to some extent that's true, because if a constitution, for example, commits itself to equality of treatment, to equality of outcome and so forth, then it is committing itself to following the laws which one has on paper, either through statute or through the development of case law. So I suppose the regularity of treatment, the regularity of outcome, these are things you'd expect a constitution which was respecting people's rights to commit itself to. So I suppose constitutions will to some extent commit themselves to respect for black letter law. Otherwise, you will have arbitrary results which would undermine fundamental rights, I guess would be my immediate response to that observation from the questioner. Thank you.
I would also want to add that I think it will defeat the whole purpose of law if there isn't, even if it's at the level of like a myth, but at least we need to hide behind that myth that the law is committed to some certainty. Otherwise, it would not be law. there would be no law if there was no commitment to what is said. But within that, the reality we have known of constitutional law also is that that probably is the area of law that has been most responsive to, change in terms of, pushing. And that's why you would, when Professor Hogg spoke, he talked about initially we would just have spoken about equality. But then, the discourse moved to equality of outcomes, equality of opportunities, and that's the responsiveness. But I would say that, and that's what people like Hayden, if there is no assumption of some degree of certainty, which is what some assuredness that this is the law. Although we spend all our life going to challenge that in court, what we do as practitioners is, we just go on and challenge, all of those things and try to suggest that this doesn't quite fit. This is not exactly what the law, what you think the law is saying is not exactly what the law was saying. And, you try to do that. That is our life. But at least we've got to hide behind that notion that the law is the law and it is the law and we all know the law. And then we will spend all our lives again trying to establish what the law is. And that's why I started out by saying, you've got that little subtle movement. We think we know the law, but we're constantly challenging the law and the law is constantly evolving in response. It believes it can afford to do too radically because the upset will be too serious. And so the courts, that is the tension between judicial activism and some stability.
Sure.
I guess I mean, this question has been answered by both the speakers wonderfully, I think, and there is nothing that I think I could add, but I would like to sort of rather bring one more, I think, strand to the question, if I may. I think this is the idea that Robert Cover brings in, jury genesis. And I think that is also very relevant in the sense that it's not just the courts through judicial activism or not just through the statutory lawmaking that we are changing the law, but the law is always constantly undergoing changes in its meaning. It's a process that goes on. And I think the idea is to understand that it goes on irrespective of whether or not the state is doing its role of changing the law, right? I think the law is changing in different other settings, non-legal settings, or at least the meaning of law is changing, not the black letter law for sure. But certainly we are adding new meanings to the law. And I think that contributes a lot also in terms of what then the vocabulary and the language that the lawmakers pick up probably after a few years, after maybe a generation, or probably the courtroom lawyering changes with a lot of, I think, changed meaning and conception. So I think that is it for I think on that account. Yeah, thank you.
Thanks very much. I think we are out of time. So it would be particularly violent on my part to summarize this absolutely, very, very rich set of comments and thoughts in such a short period of time. It's been absolutely fantastic. I'd only possibly end by thanking our three speakers for their wisdom and insight and their time in thinking so thoughtfully through the questions and the provocations of the panel. And maybe the closing thought being that as legal scholars, we always require some ground beneath our feet. How much ever we might want to be critical of black letter law, we do need to stand on something to critique. So on that note, thank you again very much.